Hello, everyone. Welcome to today's CLE. My name is Keenan Carroll. I work at the Access to Justice Office at the Utah State Bar. I'm just going to do a quick introduction for both of our presenters here today, and then I'll turn the time over to them. But today's CLA, it's sponsored by the Modest Means Program. For anyone that's interested in, you may already be participating with the Modest Means Program as an attorney, or if you're interested in the Modest Means Program, the Modest Means Attorney Program targets individuals who are just above the range of receiving free services. And so the Modest Means Program, it's ran through the bar. We help find attorneys that are willing to provide reduced rate fees for individuals who just miss that line. We do the bar does the financial screening part of that, and we'll provide those individuals that qualify 2 referrals of attorneys who have signed up for the program. In the chat here soon, I'll put a link to that program if you're interested in learning more about it. Our information's there, so you can reach out to either myself or our office, and we can either help answer your questions or provide you more information about the program. But that's kind of where this program is, the sponsoring program for the CLE today. We have Tatiana Christensen from Utah Legal Services and Cassie Madura from Jennings and Madura Law Firm. Both are very experienced with family law matters, and we're excited to have them. Cassie's one of the participating attorneys in the Modest Means Program. She's been with the program since it started, and so if you have any questions, they're both very knowledgeable, very experienced, and we hope that you enjoy what they have to say today. So I will turn the time over to them, and we'll go from there. Thank you all for coming. We appreciate it.
Thanks, Keenan.
Thank you. So I'm going to start out today. We've split up the task of sharing with you about protective orders and stalking injunctions today a little bit. We're going to tag team a little bit, and I'm going to go over the statutes that relate to civil protective orders and stalking injunctions, which are complicated, and there's a lot of definitions, so bear with me. I'm going to go over that as quickly as possible, not expecting that you're going to leave here, having memorized all of the information, but at least you'll have an idea. My thought is that at least you'll have an idea of where to look. If you take a case like this for Modest Means, you may very well be representing the respondent in a protective order or a stalking injunction, since there are organizations like Legal Aid Society of Salt Lake or Utah Legal Services that can represent petitioners in these types of cases, regardless of income. Most of the Modest Means cases that you're going to get, I would think, would be respondents. So keeping that in mind, please let us know if you have questions, and I'm just going to kind of go at breakneck speed here. And if you have a question, please do let me know. I'm going to go ahead and share my screen. Let me know if there's a problem seeing it. Hold on one second, share. And I'm going to start the slideshow here. If it works. Yep. Okay. So here we are. I am Tatiana Christensen. I work with Utah Legal Services. And let's talk about protective orders. So there are civil protective orders, there are criminal protective orders. The civil ones have an application process. For criminal orders of protection, there's no application process. That's the major difference. There are other differences. And this is something that clients and respondents do get confused about sometimes. They'll say, well, I already have an order of protection through the criminal case. They don't understand that there are different cases happening at the same time, possibly with the criminal charges and also with the civil process. So civil orders of protection do need to be served to be enforceable. They have both civil and criminal portions, and they're enforceable for a duration of order set forth by the court. In most of the protective orders, the civil protective orders we're talking about today, they can last for a maximum of 3 years. Some of the civil portions last a smaller time frame than that. But for the criminal protective orders, those are just enforceable for the period of time which the court holds jurisdiction over the defendant in the criminal case. So sometimes that can be, rarely, I would say, that would be longer than a civil protective order if it's a felony and they're sentenced to a long time in prison. But most of the time, it's going to be a period of a few months while the criminal case works through the system. These are the types of civil protective orders. I've put the code sections up there for your reference. There's a cohabitant abuse protective order, a dating violence protective order, sexual violence protective order, child protective orders, and civil stalking injunctions. There are permanent versions of each of these that have been through the court process. And then to begin, there's a temporary protective order or temporary civil stalking injunction that is usually ex parte. And we'll talk about each one of these. The lingo is different with criminal protective orders. These can be called a jail release agreement, a jail release court order, a pretrial protective order, a sentencing protective order, a continuous protective order, or a criminal stalking injunction. And it looks like I spelled stalking wrong. I apologize for that. But these are the different types and names of the criminal protective orders. There's a question in the chat. Is the criminal protective order over even when the defendant is still on probation? It depends. I'm not a criminal expert by any stretch of the imagination. You would need to know in that particular case whether the judge has ended the criminal protective order. So that would be information that you could get from the criminal case. It's not an automatic thing, and I don't know the answer to that.
I think actually, I think it can. I've seen them in cases where they usually don't extend that long. But sometimes if it's, a very serious crime, I have seen criminal no contact orders that extend through and even beyond the end of the probationary period.
Okay, thanks, Cassie. Appreciate that. What's the difference between a restraining order and a protective order? Restraining orders happen in various types of civil cases. It's a part of a civil case. It can restrain someone from doing a multitude of things. A protective order is more specific and narrower. Only certain people can obtain them according to statute. You can file it yourself. There's no money to file a protective order. Police can enforce a criminal portion and the court can enforce the civil portions of the protective orders. The penalty for restraining order is civil contempt of court, and the penalty for the criminal portions of protective orders are misdemeanor. There's another question in the chat. Are there also anti-harassment orders available, or is that covered under something else? That's pretty broad. There's no contact orders as part of protective orders. So it just depends on what kind of harassment you're talking about. And we'll get into what the court can order in a protective order in just a second. So these are the components of building a protective order or stalking injunction case. For my mind, it's easier to sort of organize around these three things. One is the relationship of the parties and or the status of the victim. The second is the nature of abuse, domestic violence, or stalking. And the third is jurisdiction and venue. There's another question in the chat. Cassie's just answering the previous question that harassment could fall under stalking injunctions, which include 2 or more acts that would cause someone emotional distress. Maybe let's revisit that question about anti-harassment after this. And if you still have questions about it, we can definitely answer that. So what kind of civil protective order should I file? Let's focus first on the relationship between the parties. First is a cohabitant abuse protective order. And if your parties are cohabitants, this is the one that I would choose to file. I'm presenting them in the order of preference. In my mind, if you qualify to file a cohabitant abuse protective order, you should file a cohabitant abuse protective order. If you don't, you ask, well, do they have a dating relationship? Then you file a dating relationship protective order. But let's go one at a time. A cohabitant abuse protective order you would file this if the parties are considered cohabitants. How is that defined by law in Utah? Cohabitants are emancipated individuals or individuals 16 years of age or older, and they are or were married to each other, are or were living as if married, are related by blood or marriage, have or had one or more children together. One is the biological parent of the other's unborn child. They reside or have resided in the same home, or are or were in a consensual sexual relationship with one another. Cohabitants under this statute does not apply to the relationship of a parent to a minor child or to minor siblings to each other. The next is a dating violence protective order. If the parties, are not cohabitants, but they are dating partners, you would file a dating violence protective order. What are dating partners? Emancipated individuals or individuals 18 years of age or older, and they are or have been in a dating relationship. A dating relationship is defined as a social relationship of a romantic or intimate nature, or a relationship which has romance or intimacy as a goal by one or both parties, regardless of whether the relationship involves sexual intimacy. Dating relationship does not include, quote, casual fraternization. If the parties are neither cohabitants nor dating partners, and the petitioner has been subjected to sexual violence, and the victim of sexual violence is not a child, you can file for a sexual violence protective order. And the child protective order is filed if the victim is a child being abused or in imminent danger of abuse, or a child who has been abused by an individual who is not the child's parent, step-parent, guardian, or custodian. Finally, if none of these other categories apply to the parties, you could file a civil stalking injunction if the respondent has stalked or is stalking the petitioner. The victim or petitioner in a civil stalking injunction may be either a minor or an adult, but an individual may not file a civil stalking injunction against a law enforcement officer, a governmental investigator, or a licensed private investigator who's acting in their official capacity. All right, so we've talked about the relationship of the parties and or the status of the victim as to choose, which protective order or stalking injunction are we talking about. Now we're going to talk about the nature of the abuse, domestic violence, or stalking. And this is where it gets real fun. So what is the definition of abuse or domestic violence? So for a cohabitant abuse protective order, any cohabitant who's been subjected to abuse or domestic violence, or to whom there's a substantial likelihood of abuse or domestic violence, may seek a protective order. Abuse in here is defined as intentionally or knowingly causing or attempting to cause another individual physical harm, or intentionally or knowingly placing another individual in reasonable fear of imminent physical harm. Domestic violence has a very long definition when you put it all together, because it's defined in Utah Code section 7736(1). It's any criminal offense involving violence or physical harm, or threat of violence or physical harm, or any attempt, conspiracy, or solicitation to commit a criminal offense involving violence or physical harm when committed by one cohabitant against another. And it includes all of these different offenses as defined in Utah Criminal Code. I'm not going to read every single one. I will, however, stop at a couple because they're not I think, common knowledge. And here's where things can get tricky with protective orders, because domestic violence, the legal definition of domestic violence as it is under the Utah Code, is not necessarily the colloquial woman on the street definition of domestic violence or abuse. Abuse in a domestic relationship can encompass a lot of different things, including spiritual abuse, financial abuse, emotional abuse, verbal abuse, a lot of things that are not recognized by law as the basis for a protective order. However, having said that, the definition of domestic violence under the Utah statute here is pretty expansive. It includes things that are obviously abusive, like aggravated assault, aggravated cruelty to an animal with the intent to harass or threaten the other cohabitant, homicide, things like that. But it also includes things like electronic communications harassment, which has a pretty broad definition and includes, contacting someone over and over and over by means of electronic communications device in a way that disrupts the user's ability to use that communications device peacefully. So if, for example, petitioner says to respondent, please don't contact me again, I'm not answering my phone, then respondent turns around and calls petitioner 40 times within an hour with no pickups, that might be considered electronic communications harassment, and that would be the basis for a protective order. Unlawful detention is another one that you see a lot. People taking keys so the other one can't leave, blocking a doorway so they can't leave a room, things like that. Violation of a temporary protective order is in and of itself a basis for getting a permanent protective order. Again, there are a lot of these different definitions of domestic violence that are included in the statute. So be aware of that, even though some things like verbal abuse are not included in the definition, statutory definition of domestic violence. The slides have been shared in the chat, and I believe Lydia Kane is also from the bar is also maybe going to email them out. I don't know, but yes, we can share the slides. For a dating violence protective order, the definition of abuse is a little bit different. It says an individual may seek a protective order if the individual is subjected to, or a substantial likelihood they'll be subjected to, abuse by a dating partner or dating violence by the dating partner. Abuse is defined the same way that it is in a cohabitant abuse protective order. Dating violence is not defined by statute, but I guess you could probably infer that it's going to be similar to the definition of domestic violence in the cohabitant abuse protective order. So the nature of abuse for a sexual violence protective order is that an individual may seek a protective order under this part if the individual has been subjected to sexual violence and is neither a cohabitant nor a dating partner of the respondent. Sexual violence is defined as rape, object rape, aggravated sexual assault, sexual exploitation or sexual extortion, or distribution of an intimate image. So it includes all of these concepts, but is not limited to that. For a child protective order, the abuse is defined as, or the entitlement for a child protective order is defined as on behalf of a child who's being abused or is in imminent danger of being abused by any individual. And before filing a child protective order, the interested person shall make a referral to the division. The division is referring to Child Protective Services here, the Division of Child and Family Services. Abuse for a child PO is defined as physical abuse, sexual abuse, or any sexual offense in the sexual exploitation or human trafficking of a child. And then for a stalking injunction, any individual who believes that the individual is the victim of stalking may file a verified written petition for a civil stalking injunction. What's the definition of stalking? Again, it's pretty specific. Stalking is defined as engaging intentionally or knowingly in the course of conduct. A course of conduct is defined as 2 or more acts directed toward an individual which the actor knows or should know would cause a reasonable person to fear for their safety or the safety of a third person or suffer other emotional distress. So stalking, the reason I say, if you have a choice, file a stalking injunction last is because it's a little bit more difficult to obtain a stalking injunction for a couple of reasons. One is that there is a requirement that a stalking injunction must be filed with corroborating evidence, such as a police report or text messages, some other kind of documentary evidence of the stalking, where that's not required for a civil protective order. The other reason is that there's some case law that prevents people from, if they're denied at the ex parte civil stalking injunction stage, it bars you from really refiling a civil stalking injunction again with those same events as the basis of your stalking injunction. So I would go ahead and file a protective order if you're able to, if you meet some of the other requirements. So lastly, I'll just mention a word about jurisdiction and venue. The jurisdiction's almost always for these types of cases in the district court, except for the case of a child protective order, which should be filed in the juvenile court. And in each case, the venue is where in the county where either party resides, is temporarily domiciled, or the events complained of took place. I will mention also that I have seen where if jurisdiction is questionable, like for example, if petitioner is here in Utah, respondent is in another state, you may be able to get established personal jurisdiction over the respondent by showing evidence that the respondent has reached out to the petitioner while knowing that the petitioner is in Utah. That is considered an act that would establish personal jurisdiction for this type of case over the respondent. So let's say that, petitioners here in Utah, they fled a respondent in another state because of the abuse or domestic violence. Respondent texts petitioner and says, I know you're in Utah, I know you've run away or whatever. And those text messages can be used as a reaching out to the petitioner in Utah to establish personal jurisdiction over the respondent. So what can the court order as part of one of these civil stalking injunctions or protective orders? It can order the respondent not to commit or threaten to commit domestic violence, abuse, or stalking. It can prohibit the respondent from contacting the petitioner. It can prohibit the respondent from going to an address of the residence or the school or the work, or the workplace of the petitioner. It can prohibit the respondent from owning any firearm. And if the parties have children, the court can make temporary custody and parent time orders that are primarily as a stopgap measure so that a custody or divorce action can be filed to create more permanent orders there. The process is that one of these orders gets filed, the civil order gets filed. The court, if they see prima facie evidence of domestic violence, abuse, or stalking, they're going to issue an ex parte temporary order, and they're going to serve that on the respondent. There is a hearing in all of the protective order cases. A hearing will automatically be set, and both parties can go to the hearing, and various things can happen at that hearing that Cassie will talk about. And then if it's found by a preponderance of the evidence that domestic violence or abuse or stalking has occurred, then they're going to issue a permanent protective order or stalking injunction, permanent because it lasts 3 years. That's going to be given to the parties, a copy of it, and they can enforce that through either the police, if it's the criminal portions of the order, or through the court's enforcement process, if it's the civil parts of the order. For a civil stalking injunction, the hearing is not necessarily automatically set. The respondent, once they've been served with the ex parte civil stalking injunction, they can request a hearing and object to the stalking injunction, and then the hearing will be set only if the respondent objects to it. I think I've come to the end of my portion. I know there may be a lot of questions, but please hold your questions for a moment, because Cassie's going to talk about sort of practical, how these hearings go, what are some of the practical, applications and practice, what am I saying? Things that you might run into in practice in doing these. Thanks. I will stop sharing my screen now.
Hello, thanks, Tatiana. That was great. I was an underachiever and I did not do a PowerPoint, but I'm happy to provide a summary of the stuff I'm going to talk about later if anybody wants it. So the stuff I'm going to talk about is just, it's not anything that you're going to find in a statute about sort of how to do these as a practical matter. Tatiana's told you where to look and what the statutes say, and there's a lot of forms online. But just first of all, when you go to, I'm focusing mostly on protective orders, but it has application in most of the other ones, except child protective orders. Keep in mind, child protective orders are in juvenile court. They're a different animal. There's usually a DCFS case that goes on with those. And generally in those cases, sort of DCFS drives the boat, but that has to happen in juvenile court. And there has to be some actual physical harm to the child. If you go in and just say the child's being emotionally abused, you're not going to get a child protective order. So that's just a note about child protective orders. When you go in to get a protective order in commissioner court, you'll always be in front of the commissioner. The commissioner will be, when you file your petition for a protective order, the petitioner will be the one that enters the ex parte order. And then you'll go into a commissioner hearing, and most of the time it is going to be a proffer hearing. So you're going to go in with whatever you've submitted to the court, your affidavits or your pictures or your medical records or whatever it is. And you're just going to tell, the lawyer's just going to tell the court, like, you know, here's my client, I'm proffering this testimony, and here's what my client would say. You can submit affidavits. The court will usually consider affidavits, will consider medical records, will consider photographs if there's injuries or other photographs of, you know, say like damaged property. The court will look at that type of evidence, but it's usually proffer. And the commissioners usually have a huge calendar. So if you go into these things thinking that you're going to get an hour, you're not. You're going to get like 15 minutes, and the commissioner's already read it, and in a lot of cases kind of already knows where they're headed. So be prepared. Don't go in there and think that you've got all the time in the world. I mean, the court will let you have your say, but generally the dockets are very, very full. So go in and be very efficient. Go in planning on proffering. Now, if you have witnesses, say, if you have supporting witnesses or supporting affidavits, it can't hurt to have those people available. So you can proffer the testimony of third parties, and that if the court has any questions, if there were witnesses to the incident, it can be helpful to have witnesses there. And the court, I often see courts or the commissioners ask questions about affidavits or other information that's been submitted. As a practical matter, a lot of times when you go into these cases, I mean, if it's something very, very clear, say, you know, somebody was injured, there's pictures, someone was arrested, there's criminal charges, you're probably going to get your protective order. Especially if there's criminal charges, you're probably going to get it. If you go in though with rather not a lot of supporting evidence, and a lot of them end up doing, you know, end up being sort of a he said, she said, you know, the abused person will say, you know, he's done this, this, and this for years, but if there's no pictures and the person's never called police, if you don't have any supporting evidence and it becomes a he said, she said, what I've found that commissioners often do is they try to allow the parties what they sometimes refer to as kind of a cooling off period. And they'll say something like, hey, you know, there's not a lot of evidence here. It's a he said, she said. Obviously, there's some issues. So oftentimes the court will just set these out, which means they'll just continue the entry of the ex parte or the temporary protective order. And they'll say like, hey, let's come back in 30 days, or let's see if the criminal charges get filed, or let's see if the divorce gets filed. So a lot of times you'll end up kind of on a review schedule with the commissioners not really wanting to put the permanent protective order in place necessarily, but also not wanting to just send the parties off on their own to perhaps have some other altercation. So a lot of times you'll end up on these sort of review hearings, like, okay, we'll come back and we'll see where things are. And I think the court is hoping that maybe the parties can work something out, or maybe they get their divorce filed and then they can enter restraints in the divorce case. So that's what I wanted to talk about next, is oftentimes protective orders, stalking injunctions, these types of things are going on in conjunction with a divorce or a protective order matter. So a lot of times you'll have two cases and they're sort of on different tracks. And most of the time, the court will end up consolidating or transferring a protective order action and the divorce action, so they're in front of the same commissioner. So you've at least got the same commissioner that will be addressing all of the issues. I have had cases though where it doesn't get transferred, and so then you're on 2 tracks in 2 cases with 2 different commissioners, which can be a pain and expensive, and sometimes you get conflicting orders. So that, just be aware of that. Usually the divorce commissioner, if you have 2 different commissioners, usually the divorce commissioner will sort of say, hey, we need to see what the protective order commissioner is going to do first before we enter orders in the divorce, since entry of the protective order will determine in a lot of cases what happens in the divorce. But if you have a divorce filed or a paternity action or some other separate action filed in conjunction with a protective order, a lot of times the commissioners will want you to or encourage you to, like, look, without entering a permanent protective order, which can cause all kinds of problems with custody and parent time issues, right? When you have protective orders in place and you have kids involved, then you have potential violations of the protective order every time you have an exchange or every time you have communication between the parties. So a lot of times the commissioners will encourage, and sometimes even just enter, they'll just say, you know, I'm not going to enter the protective order, but I am going to enter restraints in the divorce, which will provide the protection that the person is requesting. Like, you know, you're not going to go to the other person's home or their place of employment. You're not going to approach their car, those types of things. But restraints in a divorce or a paternity act or a parentage action sort of makes it easier for the parties to then carry on their business, which is if they're trying to get divorced and they've got all kinds of financial and kid issues and house issues, the restraints in the divorce make it a lot easier to do that than if there's a protective order in place, which can, you know, include no contact. So then, you know, say if someone's saying, hey, I'm coming to pick up the kids, that could be a violation of the protective order alone. And I've seen people arrested just for doing that. So, and the person who the protective order is entered against needs to be really, really careful, because a lot of times they'll say, well, they're my kids and I can, you know, certainly I can contact the other parent about the children, but it's not the case. If there's a protective order in place that says no contact, it means no contact even about the kids or even about divorce issues, unless the court specifically carves those provisions out, which is very common. So if you have a protective order action and there's children involved, and whether there's a divorce or not, the court will oftentimes carve out exceptions to the protective order. And the commissioners will usually help you do that in the courtroom and issue amended protective orders to allow for practicalities, like, you know, hey, we got to figure out how, you know, we're going to move some personal property, or we got to figure out, you know, how we're going to do child exchanges. So just make sure that you're cognizant and that you're addressing necessary exceptions if you've got kids involved or a divorce going on where people are trying to untangle, you know, their lives and their property and all those kinds of things. Usually, most people don't do this, but if your protective order is denied, if you get your ex parte protective order, and you go into the hearing and the court denies the permanent protective order, you can object to that, and you can go in front of the judge and you have the opportunity for a full evidentiary hearing, you know, regular testimony and presentation of evidence hearing before the judge, and that's under Rule 108. So you can check that out if you want to object. You don't, you're not bound to, you have the opportunity for a full hearing before the judge if you don't get what you want. Even though the protective order statute doesn't require that you submit supporting documentation like medical records or pictures or recordings, I have found that it's very, very helpful if you have some sort of corroborating evidence. It seems to me that most of the time, if it's just a he said, she said, a lot of times the court will just say, you know, I just have no way of telling whether or not this happened, and so I'm not going to enter it. So if you have supporting evidence, make sure you get that in front of the court. The timing of submitting evidence is kind of a free-for-all on protective orders. Like, say you go in and you get your ex parte protective order, and then you find out the client has a ton of text messages or pictures. you can submit that stuff and usually the commissioners will hear it, even if it's the night before or the morning of. It sort of happens on a very expedited basis. Now, the court might say something like, hey, this stuff was submitted too late. We're going to give the other side time to respond. And they might just keep the ex parte protective order in place, allowing more time. But my experience is that it's kind of a free-for-all in terms of submission of evidence. And a lot of times you go in at the last minute, especially if you're defending, you'll go in at the last minute and see stuff that you've never seen before. And usually the commissioners, if you just say, hey, look, I haven't had a chance to review this information, or I haven't had a chance to discuss it with my client or respond to it, they'll usually give you more time if you ask for it. So if you feel blindsided, most commissioners are happy to work with you on that. Regarding protective orders and divorces, there are provisions in the forms, on protective order forms, about child support. And a lot of people try to sort of get financial, well, first of all, custody. Let's talk about custody and parent time orders. Parent time, there are custody and parent time provisions in protective orders, which the court will enter and enforce. Those provisions only last 150 days. And the commissioners generally try to shift those issues into a corresponding divorce or parentage action if there is one. So normally the court will put in place sort of some Band-Aid orders, just as you know, some safety provisions in, like, okay, we're not going to have any overnights for the you know, alleged abuser, or we're not, if it's severe, they'll say there's no contact. We've had several protective orders entered where the commissioner just says there's no contact with the children during this period until we sort things out. So the court will enter custody and parent time orders in a protective order, but generally those end up getting pushed over to the divorce or parentage action. If there is no corresponding divorce or parentage action, those orders only last 150 days. And once they go away, then you're sort of back into no man's land, and you would have to file a divorce or parentage action to deal with the custody and protective order issues. Otherwise, then you just don't have any orders in place because the 150 days expires and they go away. So be cognizant of that. A lot of people try to include financial issues in their protective order, and the courts generally will not address like child support or alimony. They'll say file your divorce or file your parentage action, or we'll deal with that on a temporary order basis in the divorce action. One of the things that the court will do, though, I found in protective orders, is they will, and these are specific check the box provisions in those protective orders, is if a party is cutting off, say, cell service, if the person against whom the protective order is entered is cutting off cell service, or cutting off utilities to the home, in that way, the court will address those financial issues and, you know, order a party to continue to pay the utilities, continue to keep the cell service in place. But don't go in thinking that you're going to get a child support order, because you're not. I've rarely, if ever, seen a commissioner say, we'll deal with support issues. They'll say, you know, I'll see you in the divorce action. So don't try to do that. It probably won't be successful. If there's a violation of a protective order or a stalking injunction, there are criminal penalties for that, including felonies, and they need to be reported to police. So if a protective order is entered, even if it's an ex parte, whether it's an ex parte or a permanent, if they're violated, police need to be contacted. Now, you can also go back to the commissioner in the civil case and ask for contempt. So, I mean, for instance, I have a case where a party has been charged with 3 or 4 violations of the protective order, but isn't really facing any consequences. So we filed a motion to enforce or contempt proceedings, saying, you know what, Your Honor, like, this person just simply won't comply. They keep texting, they keep calling, they keep coming to the house, whatever it is. So you have 2 routes if you want to do, if you have a violation problem, 1 criminal and 1 civil, and the court can enter all the regular civil sanctions, fines, jail time, whatever. So there's 2 options there. There is an option if you are defending against a protective order and it looks like it's going to be entered, especially if there's, you know, a lot of evidence, or if there's criminal charges filed. One thing you can try to work out when you go in is with the other lawyer is say, look, we'll stipulate to the entry of the protective order, but I don't want to argue it. We're just going to say it's entered, period. That can sort of reduce, if you're defending against a protective order, that can sort of reduce some of your problems that come in the custody and parent time arena. If you stipulate to the entry, but you don't have the court do a full hearing and have the court make full findings of, yes, there was abuse, and yes, the abuser did X, Y, and Z. The entry of a protective order can be a little bit softer when you get to your custody and parent time issues in the divorce. So that's one of the ways to sort of reduce the sting of it a little bit. If you're defending and you think it's going to be entered, and I've done that several times, the court will say, fine, it's just entered, but I'm not making findings. That can also make it easier down the road to get rid of the protective order, as compared to if you have, a 20-line finding from the court about how horrible the abuse was. That can be a helpful way to defend. Let's see. Sometimes you can have 1, 2, or 3 of these going on at the same time, in addition to a divorce or a parentage action. I have several cases where we have protective orders, and then we also have stalking injunctions. And sometimes it's necessary to do both. Usually a protective order, like Tatiana says, sort of covers it, and it's the easier one to get. But in some cases, if other types of harassment, say to third parties, so for instance, I have a case where there's a protective order against dad for abuse of mom, and mom has had some substance abuse issues, and dad has now started contacting all of mom's providers, all of her doctors and her therapists, and showing up at their place of, showing up to the offices and showing up to pharmacies demanding information. So it was also necessary for us to get a stalking injunction to stop that behavior, because the protective order obviously doesn't doesn't prevent dad from going to third parties. So you don't have to just pick one, and sometimes you need more than one. And if you have more than one, then your case is a complete nightmare, like the ones I have. Let's see. As far as, let's see. I think I already said, with respect to child protective orders, make sure that you know what you're doing in juvenile court, because juvenile court has a whole different set of rules, a whole different set of timing. Usually there's DCFS involved. If you don't have DCFS involved, you probably aren't going to have a child protective order. I've seen it happen maybe once, but normally you're going to have a DCFS case, and sometimes you'll have a child protective order and a separate DCFS, say termination of parental rights action, going on at the same time. So juvenile court protective orders are a lot more complicated than regular. So just make sure you don't run into juvenile court if you've never been there before, because it can be kind of a minefield of rules and timing and things that don't apply in the district court. If you have a evidentiary hearing, if for whatever reason, if you object, or if the commissioner says, you know what, this case is too big and I want you to take it to an evidentiary hearing, which can happen, then a lot of times if the parties stipulate to proffer, sometimes even in front of a judge, the hearing will be a proffer hearing. And it kind of is judge dependent. Some judges are like, they don't give much time, or they don't have much patience for domestic matters, and they'll say, just proffer, I don't want you to take up a lot of my time. Other judges will give you a full evidentiary hearing if you want it. So if you're going to be in front of a judge in whatever process, I would say contact the judge's clerk and just say, hey, we have an evidentiary hearing. How does the judge prefer? Does he want a proffer? Does he want the full dog and pony show? Does he want binders in advance? All that kind of stuff. Because every judge handles it different. I think most of the time, if both lawyers stipulate to proffer, the court will do it, but it just kind of is judge specific. I think that's about it, and we're short on time. So if you guys want to start firing questions, that would be lovely.
So there was, thank you, Cassie. That was great. There was a question in the chat. What can be done about a provable perjury statement in a PO statement? And I think just my answer, I've never done this or recommended that someone do this, but I mean, I think it's just like any other potential crime. You report it to the police and you see if the police are going to do anything about it.
As a practical matter, probably nothing is the answer, unfortunately.
Yeah.
Probably nothing. You can ask for fees. You can ask for fees if someone has obtained a protective order on false bases, and the court's always looking for that when you're going into a divorce at the same time. I think the court views protective orders that are filed in conjunction with a divorce action a little more skeptically, as if, you know, just to make sure one party's not trying to use the protective order process to gain an advantage, say possession of the home and custody of the children. That's one thing the court will look at, you know, pretty closely. But if it turns out that a protective order was frivolously sought, and if it was just to gain an advantage in the divorce, which happens quite a bit, sometimes commissioners will give you fees and say, yeah, this was baseless, and you can get fees. It's easier to get fees than it is to get any prosecutor to try to prosecute someone for perjury.
Yeah. I also wanted to add about what Cassie said about getting child support or spousal support in a protective order. I agree that, especially since they changed the rules a few years ago to require full financial declarations from both parties to award any support. I've seen it very, very rarely awarded in a protective order action, but I have seen child support and or spousal support awarded as part of a protective order on a temporary basis if both parties stipulate to it, which is rare, but I've seen it happen. I just also wanted to add that Cassie mentioned contact being an issue, and if there's ongoing, you know, contact between the parties, or there needs to be contact between the parties about the kids or about parent time or about issues in the divorce, you can craft the protective order specifically that way. If the parties are in agreement that they want to be in contact about certain things, you can put that in the protective order. You know, that contact is allowed for the following, you know, topics in a civil manner or something like that. That's pretty common to have that in a protective order. But it's easier to, I would say it's easier to modify it to make it looser than it is to modify it to make it more difficult to contact. So I would start, if you're representing the petitioner, you want to start with a lot of protection and then possibly modify it down in the future rather than the other way. We do have a couple more questions in the chat. One is, can a PO stop any eviction proceedings? Not exactly. You may have some dueling, you know, courts. In an eviction can go through in another court. They're not going to be heard by the same judge usually, or the same commissioner. Eviction can go through even if the protective order awards the possession of the residence to petitioner. So I would definitely counsel a client who is not the owner of the house or the person on the lease that they need to find somewhere else to live, even if the protective order orders them possession of the residence. Another court may easily trump that. Cassie, do you have something to add there?
I agree with that. I mean, a lot of times, the two courts, just like when you have a related divorce or parentage action, the courts will try to do something that is consistent, just because they know that they don't want inconsistent orders being entered. But that one could be tricky. Because if a person is evicted from a home and then the owner of the home is allowed possession of the home, but then is prevented ownership from the protective order, if the eviction allows a person possession of the home and the person takes possession in violation of the protective order, it's still a violation of the protective order. So it can be really tricky. You'd have to go in and get the protective order modified. You'd have to say, hey, look, this protective order was entered against me, say, for instance, but I've been, and say the home was originally awarded to the wife, then the husband evicts the woman out, And then you'd have to go back to the protective order commissioner and say, hey, we need to amend the protective order because now another court has given me possession. So just be really careful about that. Like always be super vigilant about violations of protective order because the cops and the judges and commissioners take them very seriously. I also wanted to mention on violations, I've seen this happen quite a bit is, you know, if somebody starts a divorce and they want the house and they want the kids, so they file a protective order. And for instance, you know, they get dad kicked out of the house, they get, you know, an ex parte order that mom has sole physical and legal custody. And it, you know, there's not a lot of support for the protective order, but the ex parte protective order goes in place nonetheless. And there's not a lot of evidence where if you go in for the permanent, it's probably not going to be entered. But if there's a violation of the ex parte provision, even if it's not a aggressive or violent violation, and you see the husband says, I'm sorry, I want you back, here's flowers on your doorstep. I also had I'm sorry, I want you back, here's your favorite donuts on the doorstep. Here's the card, here's I'll go to therapy, I'm begging and pleading for you to take me back. The courts will pretty consistently, even if the underlying ex parte protective order is really kind of weak or thin, if there's a violation, even a benign one, like flowers or an I'm sorry, you're going to end up with a permanent protective order, even if the underlying basis of it probably wouldn't have been entered. If you violate the ex parte, even if it's not like, you know, you're not banging on someone's door, you're not doing anything aggressive or hostile, you're going to get a protective order against you. So you've got to be really make sure that you tell your clients, like, it doesn't matter if you send I had this one the other day, you're my soulmate, let's just work this out. I love you, I'm sorry. And the court said, yeah, I'm entering the protective order. And I think if the husband hadn't done that, it never would have been entered in the first place. So violations, you've got to be really vigilant about because it's any violation, any contact of any sort. Just make sure people are super vigilant about no contact, or they might end up with a violation, therefore a protective order when otherwise it would have been dismissed and it would have gone away.
That's right. I got a protective order for a client once based mostly on the fact that, because a lot of the evidence of abuse was old, but he said hello to her in the parking lot on the way into court. And that was a violation.
Yeah. Yeah. So that's what I'm
order.
saying. Even, and I had one where my client ran into the person who had the protective order at IKEA, literally walked past her in the aisle, called the cops, got arrested, and protective order entered. So
yeah, you got to be careful. So in the chat, there's a question for a civil stalking injunction. What constitutes a threat? Does it have to be a physical or any particular type of threat, or is it pretty broad to cover many types of threats, such as I'll talk to your employer, etc., about link? So the basis for stalking is a course of conduct, so at least 2 incidents on 2 separate occasions that is directed at the petitioner that would cause a reasonable person to fear for their safety, fear for the safety of a third party, and or cause other emotional distress. So that's pretty broad. Case law has shown that it's taken in the totality of the circumstances. So you have to look at the entire course of conduct taken together. And you say, okay, are these actions by respondent, is it enough to make a reasonable person in the place of the petitioner fear for their safety, fear for the safety of a third person, or suffer other emotional distress?
So the emotional distress piece makes it really broad, right? Because it's not just fear of abuse or the risk of abuse. It's if someone's doing something to stress you out, like threatening to call you and get you fired, I think if they're doing that repeatedly, that would constitute stalking. Just like in my case, where I have a party running around to all of my clients' providers and causing a huge ruckus in their reception area, that's causing her all kinds of stress because her providers are like, look, I can't deal with your ex, he's too out of control. So he's not doing anything directly to her, but it's causing her all kinds of grief and just stress and emotional trauma. So I think in that way, stalking injunctions can be a lot easier to get because you can just look at emotional distress without anything even being directed specifically to you.
Yeah. And it's not looking at, they're not looking at subjective emotional distress. Like, is petitioner really freaked out? It's the reasonable person standard. Would a reasonable person suffer emotional distress from this intentional course of conduct by the other person? Any other questions? Sorry, go ahead.
I wanted to mention, when Tatiana was talking about criminal protective orders versus protective orders like cohabitant and abuse protective orders. And if there are criminal charges filed, a lot of times you'll have both. You'll have a criminal protective order, and then you'll also have the cohabitant and abuse protective order entered. The criminal protective orders, especially if there are charges and they're severe, if they're, say, felony charges, they are unforgiving, and it is no contact, period, you're done. I mean, I've had many clients over the years who aren't allowed, even if their charges get ultimately dismissed, the criminal protective order prevents any contact with mom, with kids, with, you know, anyone related to the crime or the family. So the criminal protective orders, on the one hand, provide a ton of protection for the alleged victim, but they can be very harsh and unforgiving, and the commissioners cannot undo the criminal protective order and say, well, I'm going to allow contact for kid issues. The criminal protective order, if it's a blanket protective order, there's no contact. And I've seen them where they've gone on for over a year, where a client, and even if the charges are ultimately dismissed, then the person that has that against them is out of luck, as far as seeing their kids or any custody or parent time. So those are rough.
We're out of time. If you have any further questions, feel free to email me or call me. I'll put my number in the chat.
Me too. And I'm happy to put together a summary also, and make something. It won't be as pretty as Tatiana's, but I'm happy to put together a summary of sort of practical considerations, if anybody's interested.
And thank you, and sign up for Modest Means.
Yes, please do Modest Means. There's a ton of need and there's not enough people, so do that if you can.
Yeah. Thank you.
Thank you. Bye. How do I